The Illinois Pharmacy Practice Act, a narrative guide for MPJE Mastery Part 1. Introduction. The law in plain English. For pharmacists in Illinois, the Pharmacy Practice Act is more than a statute. It's the rulebook that defines what our profession really is, what we're allowed to do, what we're responsible for, and what happens when we fall short. Every renewal, every inspection, every counseling session ultimately traces back to this law. If you're preparing for the Illinois MPJE, understanding the Act isn't just about memorizing sections. It's about learning the story it tells, how pharmacy evolved from counting pills to practicing patient care, and how Illinois carved out its own expectations for safety and professionalism. The Act was first written in 1983 and has been updated many times since. Each revision reflects how pharmacy keeps changing: automation, vaccinations, telepharmacy, technicians taking on new roles. The language of the law might sound dry on paper, but behind every line is a patient, a prescriber, a pharmacist, and a question of trust. The purpose of the Act is simple: to protect the public by regulating the profession of pharmacy and ensuring that medications are safe, effective, and used properly. But it goes beyond that. It defines who may call themselves a pharmacist, what it means to practice pharmacy, and the standards that keep every Illinois pharmacy accountable. When you read this law through the lens of your MPJE prep, think of it as the constitution of your practice. Every other rule, controlled substance regulations, immunization protocols, collaborative agreements, fits inside the framework built here. Part 2. Foundations of the Act. The Illinois Department of Financial and Professional Regulation, IDFPR, is the authority that enforces the Act. Within it, the Illinois State Board of Pharmacy serves as the profession's voice and watchdog. Together, they handle everything from license applications to disciplinary hearings. The board isn't just a group of bureaucrats. It's mostly made up of licensed pharmacists, appointed by the governor, with one public member representing patients. The board's job is to uphold standards, interpret gray areas, and recommend changes when pharmacy practice evolves faster than the law can keep up. Think of the IDFPR as the enforcer and the board as the conscience. The board advises, the department acts. Both exist to protect the public, not to punish pharmacists. Though when mistakes happen, they ensure accountability through due process. Every pharmacist, pharmacy, and technician in Illinois answers to this structure. The Act is what gives the department the power to issue, renew, suspend, or revoke a license. It also defines what good standing means and outlines the duties that come with holding a professional credential. Part 3. The language of the law, key definitions. Before diving deeper, the Act takes care to define its terms, because in law, one word can change everything. Understanding these definitions helps you read the rest of the Act correctly and predict what the MPJE will test. Pharmacy. A pharmacy isn't just a store that sells medications. Under Illinois law, it's any location where the practice of pharmacy occurs, whether community, hospital, remote dispensing site, or mail order facility. What matters isn't the building, but the professional activities happening inside it. Pharmacist. A pharmacist is a person licensed by the department to engage in the practice of pharmacy. That license isn't just a formality. It's a legal recognition that the individual has met education, examination, and moral fitness requirements. The title pharmacist is protected. Using it without a license is a violation. Pharmacy technician. A pharmacy technician is someone who assists the pharmacist in the practice of pharmacy. They can handle many routine tasks, like data entry, counting, labeling, and inventory, but must always operate under the supervision of a pharmacist. Over time, Illinois has expanded what technicians can do, allowing them to vaccinate and take on advanced roles once properly trained and credentialed. Student pharmacist. This term describes a person enrolled in an accredited college of pharmacy who is authorized to gain practical experience. Student pharmacists can perform many of the same functions as technicians, but typically have greater clinical training and may administer vaccines or counsel under supervision. Practice of pharmacy. This is one of the most important definitions in the Act. It goes far beyond dispensing. The practice of pharmacy includes interpreting and evaluating prescriptions, compounding drugs, performing drug utilization reviews, counseling patients, participating in drug therapy management, and collaborating with other healthcare providers to improve outcomes. In short, it defines the pharmacist as a healthcare provider, not a clerk. Dispensing versus compounding. Dispensing means preparing and giving a drug to a patient according to a valid prescription. Compounding means combining or altering ingredients to create a customized medication for an individual patient. The distinction matters because compounding requires additional safeguards, documentation, and, in some cases, registration or compliance with federal compounding standards. Counseling. Counseling refers to the pharmacist's professional communication with a patient about medication use. Illinois law recognizes counseling as an integral part of the pharmacist's duty. It's not optional, it's a core element of practice meant to prevent errors and improve adherence. Institutional pharmacy. An institutional pharmacy serves a healthcare facility such as a hospital or long-term care institution. These settings operate under different logistical and regulatory expectations. For example, using medication orders instead of retail prescriptions, maintaining decentralized dispensing systems, and complying with special security and labeling requirements. Part 4. Why the definitions matter. At first glance, definitions seem like filler, the kind of material you'd skim past. But for the MPJE, they're the foundation for every question that asks, who can do what? When you see a scenario on the exam about a technician giving an injection or a pharmacist verifying a remote prescription, the question isn't just about the task. It's about whether that action fits within the Act's definition of practice of pharmacy and who's legally permitted to perform it. Illinois intentionally defines these terms broadly. That flexibility allows pharmacy practice to evolve without rewriting the entire law each time technology or scope changes. Yet it still draws bright lines. Only pharmacists can exercise professional judgment. Technicians and students may assist, but not decide. In real life, understanding these boundaries protects your license. On the MPJE, it earns you points. Part 5. The spirit of the law. Behind every section of the Illinois Pharmacy Practice Act is a single guiding idea. Pharmacists are professionals responsible for safe and effective medication use. That means being accountable for decisions, ensuring quality assurance systems are in place, and maintaining the trust of patients and prescribers. The definitions you just read aren't academic. They're the map that tells you who belongs in which role and what the law expects from each. As we move deeper into the Act, we'll explore how those roles interact, how licenses are granted and renewed, how pharmacies are inspected, and what happens when standards aren't met. But it all starts here, with understanding the words the law uses and why they were chosen. Because on the MPJE and in practice, the right word can mean the difference between compliance and violation. Part 2. Licensing and regulation. If the definitions tell us who can practice, the licensing rules explain how they get that privilege and how easily it can be lost. In Illinois, pharmacy is a licensed profession for one simple reason. The public must be able to trust that anyone handling medications is competent, accountable, and ethical. Licensure turns that trust into law. The gatekeepers, IDFPR, and the board. Every pharmacist in Illinois is licensed through the Department of Financial and Professional Regulation, often shortened to IDFPR. Inside the department, the Board of Pharmacy advises on professional standards and reviews disciplinary cases. Think of the board as pharmacists policing their own field, while the department enforces the decisions. Licensing is not a one-time stamp of approval. It's a living status that can expire, lapse, or be revoked. Keeping that license active requires not only renewal fees and continuing education, but also a continuous standard of professional conduct. Becoming a licensed pharmacist. To become a pharmacist in Illinois, a candidate must prove 3 things: education, examination, and character. Education means graduation from an accredited college of pharmacy, usually a PharmD program recognized by the Accreditation Council for Pharmacy Education. Examination involves 2 national hurdles, the NAPLEX, which tests clinical competence, and the MPJE, which tests knowledge of pharmacy law, including everything you're studying right now. Character is the least technical but most critical. The department must be satisfied that the applicant's background shows honesty and moral fitness. Past disciplinary actions or criminal convictions don't automatically bar someone, but they're reviewed carefully. The idea is that a pharmacist's integrity is as important as their pharmacology. Once licensed, the pharmacist receives a unique license number, their professional identity within the state. That number must appear on all professional documents, renewals, and posted certificates in any pharmacy where they practice. Renewal and continuing education licenses don't last forever. In Illinois, a pharmacist license must be renewed every 2 years on the even-numbered year schedule. Renewal isn't automatic. It requires a fee and proof of continuing education. Continuing education, or CE, is the state's way of ensuring pharmacists stay current. 30 hours of CE are required for each renewal cycle, with at least 1 hour in pharmacy law and 1 hour in patient safety. Courses must be from approved providers and completed before the license expiration date. Technicians, meanwhile, renew annually and must complete 10 hours of CE. CE isn't a punishment or formality, it's part of professional identity. Pharmacy evolves quickly, and the law expects pharmacists to evolve with it. A license that's renewed without learning is just a number on paper. If a license lapses, reinstatement can require extra steps: submitting an application, paying penalties, and proving current competence. Practicing with an expired license, even unintentionally, is a serious violation. Pharmacy licenses. Just as individuals must be licensed, so must the pharmacies themselves. A pharmacy license covers the physical location, the premises, equipment, and records. It's issued to a specific address and owner, and it cannot simply be transferred if ownership changes. That means when a chain buys another store or a pharmacist opens a new independent, a new license must be obtained. The law sees each pharmacy as a distinct legal entity. Each location must designate a pharmacist in charge, often called the PSC. The PSC is legally responsible for the operation of the pharmacy and its compliance with all laws and rules. They're not expected to be there every second, but they must have oversight, authority, and accountability. When the department inspects a pharmacy, the PIC's name is usually the first one on the report. Non-resident and out-of-state pharmacies. Mail order and out-of-state pharmacies shipping medications into Illinois must also hold an Illinois non-resident pharmacy license. This ensures that even if the drugs are filled in another state, Illinois patients receive the same level of protection and accountability. To qualify, a non-resident pharmacy must be properly licensed in its home state and agree to comply with Illinois standards for record keeping, counseling, and complaint resolution. If problems occur, the IDFPR has jurisdiction to investigate and discipline those pharmacies even across state lines. Technician licenses. Pharmacy technicians have their own license class, simpler than a pharmacist's, but equally serious. An applicant must be at least 16 years old, have a high school diploma or equivalent, or be working toward it, and apply for registration before beginning work. Technicians renew annually and must maintain CE, as mentioned earlier. They can advance to certified pharmacy technician status by completing additional training and national certification exams, which opens doors to more responsibility under pharmacist supervision. Technicians cannot use professional judgment. They may follow directions, but never interpret prescriptions or counsel patients. Those tasks legally belong to the pharmacist. Student pharmacist licenses. Student pharmacists practicing in Illinois must also be registered. The registration confirms that they're enrolled in an accredited program and are allowed to perform delegated functions while under direct pharmacist supervision. This lets students gain hands-on experience before full licensure. The registration expires upon graduation or withdrawal from the program, after which the individual must transition to a full license or technician role, depending on their status. Display and notification requirements. Pharmacists are required to display their licenses conspicuously at their primary place of practice. The idea is transparency. Patients should know the professionals serving them are legitimate and current. When a pharmacist changes their name, address, or employment, they must notify the department promptly. This keeps records current and ensures official notices reach the right person. Failure to update information might seem minor, but the MPJE loves these details, and in real life it can delay renewals or complicate disciplinary proceedings. Discipline and accountability licensure carries both privilege and risk. The same law that grants the license also authorizes its suspension or revocation. Grounds for discipline include fraud in obtaining a license, habitual intoxication, unprofessional conduct, violations of drug laws, or actions that endanger public health. The process is formal: notice, hearing, and opportunity for defense. The board reviews cases and recommends outcomes, but the department issues final orders. Sanctions can range from reprimands to permanent revocation. The key principle is proportionality. The punishment must fit the violation, and the goal is correction, not destruction. In many cases, rehabilitation or probation is possible if the pharmacist shows good faith effort to improve. Restoration and reinstatement. If a pharmacist's license has been suspended or revoked, it isn't necessarily the end of their career. The Act allows petitions for restoration after a designated period, often 1 year for suspension and 3 years for revocation. The applicant must demonstrate rehabilitation, competence, and fitness to return to practice. This reflects the profession's belief in second chances, as long as the public is protected and the pharmacist is sincere about rebuilding trust. Why licensing matters. Licensure might seem bureaucratic, but it's the backbone of professional identity. It separates pharmacists from technicians, regulated practice from commerce, and healthcare from retail. Every signature you write, every order you verify, flows from the authority that license represents. On the MPJE, licensing questions often hide inside scenarios: a pharmacist working with an expired license, a pharmacy changing ownership without reapplying, a technician performing duties without supervision. Each one tests whether you understand that the license is not just paperwork, it's legal permission to care for patients. Part 3: Standards of Practice and Pharmacy Operations. Once a pharmacist is licensed and a pharmacy is open for business, the question shifts from who can practice to how should that practice look. This part of the Act sets the ground rules, the daily expectations that keep pharmacies safe, professional, and compliant. It's the bridge between legal theory and the real-life rhythm of filling prescriptions, counseling patients, and managing staff. The pharmacist's professional duty. At its core, Illinois law sees the pharmacist not as a vendor, but as a healthcare provider. Every act performed under that title carries a professional duty to ensure the safe and effective use of medications. That means verifying prescriptions, identifying potential interactions, monitoring for abuse, and counseling patients on how to use their therapy properly. It also means intervening when something seems off: an incorrect dose, a missing diagnosis, or a potentially dangerous combination. If a pharmacist sees a problem and does nothing, the law treats that silence as action. In Illinois, the duty to act is part of the practice itself. Pharmacist in charge, the anchor of accountability. Every pharmacy must designate one pharmacist as the pharmacist in charge, or PSC. The PSC is more than a title. They are the point of legal accountability for the operation of the pharmacy. Their responsibilities include ensuring proper record keeping, maintaining security of controlled substances, training staff, overseeing compliance with federal and state laws, and reporting violations when necessary. If an inspection goes wrong, or if the pharmacy is cited for violations, the PIC will be named in the report, even if the issue happened on someone else's shift. That's why Illinois law allows the PA to have genuine authority over operations. They must be able to correct deficiencies and enforce compliance. A pharmacist can serve as PIC for only one pharmacy at a time, except in special cases approved by the department. When a PIC leaves or changes position, the pharmacy must notify the department within a defined period to stay compliant. Supervision and delegation. Pharmacists are allowed to delegate tasks, but never judgment. Pharmacy technicians, student pharmacists, and supportive staff can help with many operational duties: typing, counting, labeling, inventory management, but they cannot interpret prescriptions, make clinical decisions, or counsel patients. Illinois recognizes different tiers of technician roles, including certified and licensed technicians, as well as students. Each has a defined scope. The supervising pharmacist must always be physically or electronically available to oversee their work and intervene when necessary. If a pharmacy uses remote or telepharmacy models, the same supervision standards apply. The technology may change, but accountability does not. Prescription requirements. Every prescription must contain certain essential information: the patient's name, the date, the drug name and strength, directions for use, prescriber's information, and the prescriber's signature or authorized electronic signature. Pharmacists are responsible for verifying authenticity and appropriateness before dispensing. That includes checking for completeness, evaluating drug interactions, ensuring correct dosage, and confirming that the prescription complies with both state and federal law. Refills, transfers, and substitutions all come with their own set of rules, but the guiding principle remains constant. A pharmacist may never dispense unless the prescription is valid and professionally appropriate. Drug product selection, generic substitution. Illinois allows pharmacists to substitute a less expensive, therapeutically equivalent drug product for the brand prescribed, provided the prescriber has not prohibited substitution. The pharmacist must inform the patient of the substitution, label the product accordingly, and record the details. If the prescriber writes brand medically necessary, the pharmacist must honor that instruction. For the MPJE, remember, generic substitution is a privilege, not an obligation. It's meant to reduce cost and improve access, but it's always bound by clinical judgment and communication with both the patient and the prescriber. Patient counseling. Counseling is not optional in Illinois. It's a professional duty. The pharmacist must offer to counsel every patient receiving a new prescription. That offer can be verbal or written, but the counseling itself, if accepted, must be personal and professional. Topics typically include drug name, use, directions, side effects, storage, and precautions. Counseling may be delegated to a student pharmacist under supervision, but never to a technician. Failure to offer or document counseling can lead to disciplinary action, and it's a frequent MPJE trap question. On the exam, always assume counseling is required unless clearly refused by the patient. Record keeping and documentation. In pharmacy law, if it isn't documented, it didn't happen. Illinois requires pharmacies to maintain detailed records of prescriptions, transfers, inventories, and controlled substance logs. These records must be retrievable for inspection by the department or law enforcement. Most records must be kept for 5 years, though some federal controlled substance records require only 2. The longer Illinois standard generally prevails. Documentation also includes policies, training logs, immunization records, and medication error reports when applicable. The goal is not to create paperwork for its own sake, but to preserve a verifiable trail of accountability. Confidentiality. Pharmacists are guardians of private health information. Any details about a patient's medication, condition, or therapy must remain confidential unless disclosure is required by law or authorized by the patient. This protection extends to all forms, verbal, written, or electronic. Discussing a patient's medications in a public area, leaving printouts visible, or sharing information without consent violates both state and federal privacy laws. On the MPJE, confidentiality violations are viewed seriously because they go beyond ethics. They're considered breaches of professional duty. Emergency dispensing and professional judgment. Illinois allows limited flexibility in emergencies. When a patient's health is at risk and the pharmacist cannot reach the prescriber, a pharmacist may exercise professional judgment to provide a short supply of maintenance medication. This isn't a free pass. It must be reasonable, well documented, and based on prior patient history. Controlled substances generally cannot be dispensed under emergency refill provisions unless explicitly allowed by federal law. The law trusts pharmacists to use discretion when lives are at stake, but expects careful follow-up afterward. Compounding and labeling. Pharmacists may compound medications for individual patients based on valid prescriptions. Office-use compounding, bulk manufacturing, and resale compounding are restricted unless the pharmacy is appropriately registered or compliant with federal standards like USP 795 and 797. Every compounded medication must be labeled with the patient's name, prescriber's name, ingredients, preparation date, and beyond use date. Documentation must include formulation records and batch logs. Compounding is a blend of science and regulation, and it's a frequent MPJE focus because of safety and contamination concerns. Inspections and compartment has the authority to inspect any pharmacy, records, or equipment at reasonable times. Inspections are not accusations. They're quality checks meant to ensure compliance and protect patients. Pharmacists must cooperate fully, provide requested documents, and correct deficiencies promptly. Refusing inspection or concealing records can trigger disciplinary action far more serious than the original violation. The smartest pharmacies treat inspections as opportunities for improvement, not adversarial encounters. Pharmacy closure and change of ownership. When a pharmacy closes permanently or changes ownership, the law requires proper notification and record transfer. Controlled substances must be inventoried and disposed of according to DEA and state procedures. Prescription files must be securely stored or transferred to another licensed pharmacy accessible to patients. The department must be notified in advance, and the pharmacy's license becomes void once the closure or ownership change takes effect. For the MPJE, remember, pharmacy licenses do not transfer with ownership. New owner, new license. Professional standards and discipline. Beyond specific rules, the Act expects all pharmacists to conduct themselves with honesty, integrity, and competence. Actions such as diversion, falsifying records, breaching confidentiality, or practicing while impaired are treated as unprofessional conduct. The board has discretion to evaluate intent, harm, and context. Rehabilitation programs exist for those struggling with substance use or health issues, emphasizing recovery and safe return to practice rather than punishment. The profession's credibility depends on accountability, and Illinois law protects both the public and the pharmacist by providing fair, structured processes for discipline and restoration. The everyday reality of compliance. Compliance in Illinois pharmacy practice isn't about memorizing checklists. It's about building habits, keeping the logbook current, verifying credentials, counseling every patient, maintaining CE, and treating each signature as a legal act. For the MPJE, this mindset is gold. Most questions aren't about obscure numbers or dates. They're about recognizing when professional judgment and legal duty intersect. The Illinois Pharmacy Practice Act doesn't expect perfection. It expects vigilance, transparency, and care, the same traits that define a good pharmacist. Part 4, Discipline, Enforcement, and Due Process. Every profession that carries public trust also carries the potential for misuse. The Illinois Pharmacy Practice Act recognizes this and creates a system not only to punish misconduct, but to guide pharmacists back toward compliance and integrity. Discipline in this context isn't about catching people. It's about protecting the public, correcting behavior, and maintaining faith in the profession. The foundation of enforcement. The authority to discipline pharmacists, pharmacies, and technicians comes from the Department of Financial and Professional Regulation, IDFPR. Within it, the Division of Professional Regulation investigates complaints, and the Board of Pharmacy reviews the evidence and makes recommendations. The department holds the final say, but it rarely acts alone. The board serves as the expert body, pharmacists evaluating pharmacists, ensuring that decisions reflect both the spirit of the law and the realities of practice. What triggers discipline? Disciplinary action usually begins with a complaint from a patient, employer, coworker, prescriber, or even another pharmacist. Once a complaint is filed, the department determines whether it falls within its jurisdiction and whether an investigation is warranted. Grounds for discipline include a wide range of behaviors. Some are obvious, others are more subtle. Here are the most common categories you should understand for the MPJE and for real-world awareness. 1. Fraud or misrepresentation. Providing false information on an application, forging prescriptions, or falsifying records. 2. Criminal activity. Felony convictions, drug-related offenses, or actions involving moral turpitude. 3. Substance abuse or impairment. Practicing while under the influence of alcohol or drugs or while mentally unfit to perform duties safely. 4. Violation of drug laws. Any breach of federal or state pharmacy or controlled substances regulations. 5. Unprofessional conduct. Behavior that dishonors the profession, including disrespect toward patients, breaches of confidentiality, or unethical marketing. 6. Negligence or incompetence. Failing to maintain the standard of care expected of a pharmacist, resulting in patient harm or risk. For technicians, common grounds also include performing duties beyond their scope or working without supervision. The disciplinary process. When a potential violation is identified, the department opens an investigation. Investigators may review records, interview witnesses, and request written statements. If evidence supports the allegation, the department files a formal complaint, and the licensee is notified. From that point, the pharmacist or pharmacy has the right to due process, meaning notice, the opportunity to respond, and a fair hearing. A typical disciplinary case proceeds as follows. 1. Investigation. The department gathers facts and determines whether probable cause exists. 2. Notice of charges. The licensee receives a written notice outlining the alleged violations. 3. Hearing. The case is presented before an administrative law judge or hearing officer, with the board often participating or advising. 4. Recommendation. The board reviews the hearing record and issues a recommendation to the director of the department. 5. Final order. The department issues its decision, which could include dismissal, probation, suspension, revocation, or other penalties. This process mirrors court procedure, but it's administrative, not criminal. Its goal is correction and protection, not punishment for its own sake. Types of disciplinary actions. The Act allows a range of outcomes depending on the severity and circumstances of the violation. Reprimand, a formal warning placed in the licensee's file. Probation. The licensee continues to practice under specific conditions, such as supervision, counseling, or additional education. Suspension. The license is temporarily inactive. The pharmacist may not practice until the suspension is lifted. Revocation. The license is canceled. Reapplication may be allowed only after several years and proof of rehabilitation. Fines. Monetary penalties, often combined with other sanctions. Cease and desist orders, immediate stop orders for unlicensed practice or unsafe conditions. The department can tailor penalties to the situation, harsher for deliberate violations, more lenient for unintentional errors that are promptly corrected. Rehabilitation and Recovery Illinois recognizes that pharmacists are human, capable of mistakes, addiction, or poor judgment, but also capable of recovery. The Pharmacy Recovery Program, PRP, managed under IDF-PR, provides a confidential route for pharmacists and technicians struggling with substance use or mental health issues. Participants may enter voluntarily or as part of a disciplinary order. The goal is to rehabilitate rather than expel. Completion of the program can allow a pharmacist to retain or regain their license under monitored conditions. Failure to comply, however, can trigger full disciplinary action. For the MPJE, know that the law values rehabilitation over retribution, but public safety always comes first. Emergency actions. In serious cases such as diversion, fraud, or imminent public danger, the department can issue a summary suspension, an immediate halt to a license before a hearing. This power is used rarely, but decisively. It's a protective measure, not a punishment. The hearing follows soon after to determine whether the suspension should remain or be lifted. For MPJE purposes, summary suspension means immediate stop, hearing later. Restoration and reinstatement. After revocation or suspension, a pharmacist may apply for reinstatement once the required time has passed, often 1 year for suspension and 3 years for revocation. The petition must demonstrate rehabilitation, competence, and fitness to return to practice. This can include evidence of treatment, continuing education, or positive community involvement. The department reviews each case individually. Restoration isn't guaranteed, but it's possible when genuine reform is proven. Administrative fines and civil penalties. In addition to disciplinary sanctions, the department may impose fines for minor violations, such as failure to renew on time, incomplete records, or improper display of licenses. These fines are meant to enforce compliance, not punish malicious intent, but repeated minor violations can accumulate into a serious pattern, so even small details matter. For the MPJE, remember, administrative penalties are about correction and deterrence, not moral judgment, appeals and judicial review. If a pharmacist disagrees with the department's final decision, they can seek judicial review in circuit court. This ensures fairness and prevents arbitrary enforcement. However, courts rarely overturn decisions unless the department clearly acted outside its authority or ignored due process. For the MPJE, the takeaway is simple. Due process exists at every stage. The system is built to be fair, not one-sided. Unlicensed practice and false representation. Practicing without a license, or while suspended, expired, or revoked, is one of the gravest offenses under the Act. Each instance is treated as a separate violation, subject to fines and potential criminal charges. Similarly, using titles like pharmacist or PharmD without proper licensure constitutes false representation. The law guards the public's ability to distinguish trained professionals from imposters. If you see this on the MPJE, the answer is always that unlicensed practice equals violation, regardless of intent. Um, Inspections, investigations, and cooperation. The department and its investigators have the legal right to inspect pharmacies, review records, and interview staff. Refusal to cooperate, obstructing an investigator, or providing false information during an inspection can lead to discipline even if no original violation is proven. Always remember, cooperation and documentation are your strongest defenses, both on the test and in real practice. The philosophy behind enforcement. The Illinois Pharmacy Practice Act is firm but fair. It acknowledges that errors happen, but expects honesty, correction, and accountability in response. The goal is not to create fear, but to maintain trust, the foundation of every healthcare profession. When you stand before a patient, you represent not just yourself, but an entire system built on public confidence. That's why the law holds you to a high standard, and why the MPJE so often tests not just knowledge, but judgment. Part 5: Collaboration, Clinical Practice, and the Evolving Role of the Pharmacist. Pharmacy practice in Illinois has never been static. When the first version of the Pharmacy Practice Act was written in 1983, pharmacists were largely viewed as dispensers, professionals who verified prescriptions, ensured accuracy, and handed over medications with brief advice. Today, that world is gone. The law has expanded to recognize pharmacists as clinicians, educators, and partners in patient care. The evolution is written directly into the Act, quietly but unmistakably. The shift toward patient care. The Act's definition of practice of pharmacy has steadily grown to include clinical judgment, therapeutic monitoring, and interprofessional collaboration. Pharmacists no longer simply fill prescriptions, they participate in the design and ongoing management of therapy. They counsel patients, monitor outcomes, and adjust regimens under authorized agreements. Illinois law explicitly states that pharmacists may engage in patient care services that optimize drug therapy outcomes, including participation in drug therapy management, administration of medications, and collaboration with prescribers. This evolution reframes the pharmacist's identity from a dispenser to a direct healthcare provider. Collaborative pharmaceutical care agreements. One of the most important mechanisms for this expanded scope is the Collaborative Pharmaceutical Care Agreement, often called a CPCA. A CPCA is a written agreement between a prescriber, such as a physician, advanced practice nurse, or physician assistant, and a pharmacist that outlines specific patient care functions the pharmacist may perform under defined conditions. This might include adjusting drug dosages, formulations or administration schedules, ordering and interpreting laboratory tests, initiating or modifying therapy for chronic diseases, providing immunizations or preventive care. The agreement must clearly describe the scope, procedures, and responsibilities of both parties. It must also be kept on file at the participating pharmacy and made available for department inspection upon request. The key concept: the pharmacist acts collaboratively, not independently. The prescriber remains the ultimate authority but delegates certain clinical responsibilities within agreed boundaries. Immunization authority. Illinois pharmacists can administer vaccines to patients 7 years of age and older. This authority represents a major extension of clinical responsibility, and it's often tested on the MPJE. To immunize, a pharmacist must complete an accredited immunization training program, maintain current basic life support BLS certification, follow CDC guidelines for vaccine storage, administration, and reporting, keep appropriate documentation and notify the patient's primary care provider, if applicable. Student pharmacists and trained technicians may also administer vaccines under direct supervision once they meet the same training requirements. The law treats immunization as an extension of the pharmacist's clinical role, not a separate specialty. It's a public health function rooted in access and prevention. Under state protocols, Illinois allows pharmacists limited prescriptive authority under specific statewide protocols. These protocols don't require a CPCA and are established by the department in collaboration with the board and public health agencies. Examples include naloxone dispensing to reverse opioid overdose, hormonal contraceptive prescribing under an approved protocol, tobacco cessation therapy involving nicotine replacement products, HIV pre-exposure prophylaxis, PrEP, and post-exposure prophylaxis, PEP-P, under 2024 amendments. In each case, the pharmacist follows a standardized protocol, performs required screening and counseling, and documents the encounter. The key distinction: a CPCA is between a pharmacist and a prescriber. A state protocol is between the pharmacist and the public, authorized directly by law. Medication Therapy Management, MTM. Pharmacists in Illinois are explicitly recognized as providers of medication therapy management services, systematic processes for optimizing patient outcomes. MTM includes reviewing medication regimens for safety, appropriateness, and cost-effectiveness, identifying problems like duplication or non-adherence, and collaborating with prescribers to resolve them. MTM is usually reimbursed under insurance or state programs. Legally, it reinforces the pharmacist's professional autonomy and clinical judgment. On the MPJE, MTM is often tested indirectly through questions about counseling, therapeutic adjustments, or collaborative practice. Remember, MTM isn't a separate license or certification. It's a recognized function under the practice of pharmacy. Telepharmacy and technology-assisted practice. The law now recognizes that pharmacy doesn't always happen in one room. Telepharmacy allows pharmacists to supervise remote dispensing sites electronically, review prescriptions through secure digital systems, and counsel patients via audio-visual connections. Illinois requires telepharmacy operations to meet the same standards as in-person pharmacies: verified oversight, real-time communication, and secure data handling. Remote sites must be licensed, and a pharmacist must be available to review and verify every prescription before it reaches a patient. The principle is simple: distance cannot dilute responsibility. Emergency preparedness and public health roles. Illinois pharmacists play vital roles in emergencies, pandemics, natural disasters, or drug shortages. The Act gives pharmacists limited flexibility to provide emergency refills or administer medications when a physician is unavailable. During declared public health emergencies, the department or governor may temporarily expand scope of practice, allowing pharmacists to vaccinate broader age groups, dispense understanding orders, or provide critical supplies without new prescriptions. The law trusts pharmacists to act with professional judgment when lives depend on access and time. Documentation and post-event reporting are always required, but the emphasis is on care, not red tape. Clinical documentation and communication. With greater clinical authority comes greater responsibility for record keeping. Pharmacists must document all interventions: changes to therapy, immunizations, counseling sessions, laboratory results, and any communications with prescribers. This documentation becomes part of the patient's medical record and serves both clinical and legal purposes. If questioned later, thorough records demonstrate that the pharmacist acted within scope, with justification, and in collaboration. On the MPJE, these questions often appear as scenarios. A pharmacist adjusts a dose under a collaborative agreement, but fails to record it. Is that a violation? Yes. Even correct actions can become violations if they lack documentation. The expanding circle of responsibility. As pharmacists gain clinical roles, the law expects more from them: sharper judgment, better communication, and active participation in care teams. This doesn't mean pharmacists are replacing prescribers. It means they're stepping into the roles for which they're uniquely trained. Medication experts bridging science and practice. Illinois law reflects that respect. It doesn't hand out power casually. It entrusts it conditionally, under clear structures of accountability and collaboration. What this means for the MPJE: expect the exam to test both your knowledge and your reasoning. It won't just ask, can pharmacists administer vaccines? It might ask, a 10-year-old patient requests a flu shot. Can a pharmacist administer it without a prescription? The correct answer hinges on understanding scope, training, and age limits. The MPJE loves gray zones: collaborative agreements, telepharmacy supervision, protocol authority. The key is to think like the law, balancing flexibility with control, innovation with safety. If a question asks what a pharmacist may do, always ask, is it within the practice of pharmacy? Is there statutory or protocol authority? Is it properly documented and supervised? If all are yes, it's likely lawful. The spirit of the modern act. The Illinois Pharmacy Practice Act has evolved from a regulatory checklist into a living reflection of healthcare progress. It acknowledges pharmacists as part of the clinical team, trusted to educate, to intervene, and to innovate as long as patient safety stays at the center. It's a quiet revolution. The law no longer sees pharmacists behind the counter, but beside the patient. Part 6. Controlled Substances, Security, and Record Requirements. If the heart of pharmacy practice is trust, then nowhere is that trust tested more than in the handling of controlled substances. These medications save lives when used appropriately and destroy them when they're diverted, abused, or poorly managed. Illinois law weaves controlled substance responsibilities into the Pharmacy Practice Act and into a separate but parallel framework, the Illinois Controlled Substances Act. To practice safely and pass the MPJE, you must understand how these two bodies of law work together. One governs pharmacists as professionals, the other governs drugs as commodities with potential for abuse. The big picture. Every controlled substance is tracked from manufacturer to patient, a closed system designed to prevent diversion. Pharmacies, prescribers, and distributors are all part of that chain. Pharmacists, in particular, sit at the final checkpoint. When a prescription for oxycodone or Adderall slides across the counter, the pharmacist isn't just checking dosage, they're verifying legitimacy, legality, and medical purpose. Illinois expects pharmacists to act as both caregivers and gatekeepers. Failure to do either role responsibly can trigger both professional and criminal penalties. DEA and state registration. Before a pharmacy can handle controlled substances, it must hold two registrations: a federal DEA registration and a state controlled substances license issued by the Illinois Department of Financial and Professional Regulation. Both must be active and specific to the pharmacy's location. Each pharmacist who dispenses controlled substances under the pharmacy's license acts as an agent of that registration. If ownership, address, or name changes, new registrations must be obtained. They don't transfer automatically. Security standards. The law requires that controlled substances be stored securely and protected from theft or diversion. That means Schedule II drugs are kept under lock and key in a cabinet or safe. Schedules 3 VI may be dispersed throughout stock to deter theft, but must remain under constant supervision. Access is limited to authorized personnel only. Any theft or significant loss must be reported immediately to both the DEA and the department, typically within 1 business day. Security also includes digital integrity. Electronic prescription systems, inventory records, and logs must be protected against unauthorized access or alteration. Prescription validity and red flags. A pharmacist may dispense a controlled substance only for a legitimate medical purpose and in the usual course of professional practice. If a prescription looks suspicious, unusually high quantities, inconsistent refills, mismatched diagnoses, or doctor shopping patterns, the pharmacist must investigate before dispensing. This isn't optional. The pharmacist's signature on a controlled substance prescription is an endorsement of legitimacy. Failing to question an obviously suspicious prescription can be treated as professional misconduct. The law expects vigilance, not paranoia. But if it feels wrong, you pause, verify, and document. Partial fills and refills. Schedule II drugs generally cannot be refilled. Partial fills are allowed only if the total quantity dispensed does not exceed the prescribed amount and the remainder is provided within 72 hours or longer in certain hospice or LTCF cases. Schedules 3, 4, and V may be refilled up to 5 times within 6 months from the date of issuance, unless the prescriber authorizes otherwise. All partial fills and refills must be recorded with date, quantity, and dispensing pharmacist's initials. For MPJE purposes, the time and quantity limits matter, but what's most tested is the record keeping and pharmacist's judgment. Emergency dispensing of Schedule II Illinois allows limited emergency dispensing of a Schedule II controlled substance when 1. Immediate administration is necessary for patient care, 2. No alternative treatment is available, and 3. It's not possible for the prescriber to provide a written prescription immediately. The pharmacist may dispense only the minimum necessary quantity and must receive the written prescription within 7 days. If it doesn't arrive, the pharmacist must notify the DEA and the department. It's a classic MPJE scenario. Know the time frame and follow-up duties. Transfers and record keeping. Controlled substance prescriptions may be transferred only once between pharmacies for refill purposes, unless they share a real-time database that updates instantly, like within the same chain. Each transfer must document the names, addresses, and DEA numbers of both pharmacies, the name of the transferring pharmacist, dates and remaining refills, original prescription number, and issue date. Both pharmacies must keep these records for 5 years in Illinois. Accuracy here is everything. The smallest omission can count as a record-keeping violation. Inventory requirements. Every controlled substance registrant must maintain a complete inventory of all controlled substances on hand at least every 2 years. Illinois also expects a perpetual inventory for Schedule II drugs in many institutional settings. Inventories must include the drug name, strength, form, and quantity, the date and time, opening or closing of business, the name and signature of the person conducting the inventory. If drugs are expired or returned, they must remain in the count until properly destroyed or transferred. Disposal and destruction. Expired, damaged, or unwanted controlled substances can't simply be thrown away. Pharmacies must follow approved destruction methods, typically by returning to a reverse distributor or conducting on-site destruction under DEA authorization. Documentation must include the method, date, witnesses, and quantities. For MPJE questions, focus on accountability and documentation. Every milligram must be traceable. Controlled substance emergency kits. Long-term care facilities may maintain emergency medication kits containing controlled substances if permitted by their licensing regulations. These kits must be obtained from a DEA-registered source, be secured per Department of Public Health standards, and have detailed records of access, use, and restocking. Only authorized personnel may access the kit, and any use must be documented immediately. The pharmacist consultant or provider pharmacy retains oversight responsibility. Prescription Drug Monitoring Program, PDMP. Illinois law mandates that pharmacists check the PDMP before dispensing Schedule IIV medications, except in limited circumstances, e.g., inpatient hospital use. The PDMP tracks patient-controlled substance histories to identify potential misuse or overlapping prescriptions. Failure to check the PDMP when required can lead to professional discipline. For the MPJE, remember, PDMP equals prevention tool, not optional. Documentation of the check is part of best practice. Record retention and retrieval pharmacies must maintain all controlled substance records, prescriptions, inventories, invoices, transfers, destruction logs for at least 5 years. Records must be stored in a way that allows prompt retrieval, typically within 48 hours upon department request. Electronic systems are acceptable if they are secure, backed up, and capable of printing or exporting records for inspection. The takeaway: the law doesn't care about format, only about accessibility, accuracy, and integrity. Responsibility and liability. Ultimately, the pharmacist is responsible for the accuracy and legality of every controlled substance transaction that leaves the pharmacy. Even if a technician typed the label or another pharmacist verified it, each dispensing pharmacist shares responsibility. That's why documentation, double-checking, and professional skepticism are so heavily emphasized in Illinois law. On the MPJE, questions about controlled substances are rarely about memorizing numbers. They're about decisions that prevent diversion and protect patients. Inspections and enforcement. The department and DEA may inspect controlled substance records, inventories, and security systems at any reasonable time. Pharmacies must cooperate fully and provide access to any requested information. If discrepancies are found, corrective action must be taken immediately. Repeat or willful violations can result in suspension or revocation of both state and DEA registrations. The balancing act controlled substance law is a tightrope between accessibility and control. The pharmacist stands at the midpoint, responsible for ensuring that patients in pain receive care while keeping dangerous drugs out of the wrong hands. Illinois law recognizes how delicate that balance is. That's why it gives pharmacists both authority and accountability. You're trusted with some of the most powerful substances in medicine, and that trust is earned every time you check a PDMP, question a dose, or refuse a suspicious prescription. Part 7. Pharmacy ownership, permits, and operational requirements. So far, we've talked about the people who make a pharmacy work: pharmacists, technicians, and the regulators who keep them accountable. Now we turn to the places where pharmacy happens: the stores, institutions, and facilities licensed to handle prescription drugs. The Illinois Pharmacy Practice Act treats pharmacies not as businesses first, but as professional environments. To open one, you don't just need capital, You need permission, oversight, and an ongoing commitment to public safety. Pharmacy permits and ownership. Every pharmacy in Illinois must hold a valid pharmacy license, sometimes called a permit. This license is issued to a specific location and owner, never as a generic credential. If either changes, the license becomes void. Ownership can take many forms: an individual pharmacist, a partnership, a corporation, or a health system entity. Regardless of structure, the owner bears ultimate legal responsibility for compliance with all pharmacy laws. For chains and hospital systems, each branch location must have its own permit. There's no umbrella license that covers multiple sites. Application and inspection. Before a pharmacy opens, it must submit an application to the department describing the ownership structure and names of key personnel, the proposed address and floor plan, the name of the pharmacist in charge, PIC, evidence of compliance with federal and state drug laws. Once approved on paper, the department conducts an on-site inspection. Inspectors verify security, record systems, equipment, storage conditions, and workflow design. No pharmacy may open its doors to the public until this inspection is passed and the license is issued. It's the state's way of saying, you may now practice, but we'll be watching. Display of license. Just as pharmacists display their individual licenses, each pharmacy must post its facility license in a conspicuous location visible to patients. This transparency builds trust, a silent promise that the business is legitimate, inspected, and held to professional standards. Change of ownership or location. Whenever ownership or address changes, the law treats it as a new entity. A new application must be filed, and the previous license expires automatically. This ensures that each physical site undergoes review for compliance before reopening under new control. For the MP member, this rule of thumb: ownership change equals new license. Closing a pharmacy. Closing a pharmacy involves more than locking the doors. Before shutting down permanently, the owner must: 1. Notify the department in writing, typically 30 days in advance. 2. Conduct a complete inventory of controlled substances. 3. Arrange for lawful transfer or destruction of drug stock. 4. Securely store prescription files and patient records for at least 5 years. 5. Remove or deface all signs, labels, life, and advertising that imply the site is still a functioning pharmacy. This process protects patients from confusion and preserves the integrity of prescription records. Operational requirements. Every Illinois pharmacy must maintain adequate lighting, ventilation, and temperature control. Equipment and references appropriate to the services offered. Secure storage for all prescription drugs. Continuous professional supervision by a licensed pharmacist whenever open for business. No prescription or drug product may be dispensed unless a pharmacist is physically or electronically present and verifying accuracy. Pharmacies must also maintain written policies for handling of errors and near misses, technician duties and training, sanitation, security, and quality assurance, disaster recovery or emergency operation. These policies aren't window dressing. Inspectors will ask for them. Hours of operation and pharmacist availability. Pharmacies must operate only when a pharmacist is on duty. If the pharmacist steps away temporarily, prescriptions may not be dispensed until they return. Technicians may continue non-dispensing tasks, but patient access must be restricted. For the MPJE, expect questions about what can continue when the pharmacist is absent. Answer: administrative tasks, yes. Dispensing, no. Advertising and representation. Illinois law prohibits false or misleading advertising by pharmacies. Promotions must be truthful about pricing, availability, and professional services. Using terms like specialist or expert in a way that misleads the public can invite disciplinary action. The principle is simple: commercial freedom ends where patient trust begins. Ownership, accountability. Owners, whether pharmacists or corporations, are jointly responsible with the PIC for compliance. If a chain store violates the act, both the company and the individual pharmacist in charge can face discipline. Ownership cannot hide behind the pharmacist, and the pharmacist cannot ignore ownership's policies. Accountability flows both ways. Remote dispensing sites and telepharmacy. Illinois allows remote dispensing sites under strict conditions. These sites operate under a parent or home pharmacy's license and must be connected by real-time audio-visual technology. A pharmacist at the home site verifies prescriptions, counsels patients via video link, and oversees technicians or trainees working remotely. Each remote site must meet the same security and record-keeping standards as a traditional pharmacy. This model expands access to care in rural or underserved areas, but it also expands responsibility. The pharmacist's legal duties don't shrink just because the patient is miles away. Institutional and health system pharmacies, hospitals, and long-term care facilities maintain institutional pharmacy licenses. They operate under medication orders rather than retail prescriptions and must follow facility-specific rules for labeling, distribution, and chart documentation. Institutional pharmacies often use decentralized dispensing systems or automated cabinets. Illinois law requires that these systems record who accessed each dose, when, and for which patient, creating a digital paper trail for every movement of medication. Even within large institutions, the pharmacist remains the legal custodian of drug distribution integrity, quality assurance, and error prevention. Every pharmacy must have a system for detecting and addressing medication errors. The law doesn't demand zero mistakes, it demands systems that learn from them. Quality assurance records are typically internal and protected from public disclosure, but they demonstrate a culture of safety and improvement. The best pharmacies treat QA programs not as paperwork, but as daily habits, checklists, double checks, and post-incident reviews. Pharmacy ownership by non-pharmacists. Illinois allows non-pharmacists to own pharmacies, but only if a licensed pharmacist is employed and designated as the pharmacist in charge. The owner cannot interfere with the pharmacist's professional judgment or dictate dispensing decisions. If they do, both the owner and pharmacist risk disciplinary action. The message is clear. Business may own pharmacy, but only pharmacists run it. Record transfer and retention. All prescription records, patient profiles, and controlled substance logs must be retained for 5 years and be readily retrievable for department inspection. Upon closure or sale, records must be transferred securely to another licensed pharmacy or to storage approved by the department. Lost or destroyed records are treated as serious compliance failures. Why this section matters for the MPJE. Ownership and operational rules rarely appear as direct definition questions. They appear as situations. Examples you might see: a pharmacy changes ownership but keeps filling prescriptions under the old license. Violation. A technician dispenses while the pharmacist is out for lunch. Violation. A corporate owner pressures a pharmacist to fill early refills against judgment. Violation. These questions test not just memorization, but your ability to think like the department, protect patients first, regulate commerce second. The balance between business and profession. The Pharmacy Practice Act acknowledges that pharmacies are businesses. They buy, sell, and compete, but it draws a firm line. The practice of pharmacy is a professional function, not a retail transaction. Every sign on the wall, every decision behind the counter is governed by that distinction. Running a pharmacy in Illinois means running a business built on ethics. That's why ownership rules exist, not to limit opportunity, but to ensure that profit never outruns professionalism. Part 8, Public Health Functions, Reporting, and Emergency Authorities. If earlier chapters focused on the pharmacist's role in individual care, this one looks outward, to the profession's role in protecting the public. Pharmacists are not just medication experts, they are frontline public health professionals. Illinois law acknowledges this with provisions for emergency care, disease prevention, and required reporting. These powers and responsibilities come alive during crises, epidemics, and moments when pharmacists must act before anyone else can. Pharmacists as public health partners. The Illinois Pharmacy Practice Act places pharmacists squarely within the state's public health framework. Whether through vaccinations, emergency dispensing, or education, pharmacists are often the most accessible health professionals in a community. When a patient walks in asking about flu shots, naloxone, or antibiotics, they're not seeking a retail service. They're seeking a trusted source of information. The law empowers pharmacists to meet that need confidently and safely. Immunizations and preventive health pharmacists in Illinois may administer vaccines to patients 7 years of age and older. This age threshold is important. It reflects the balance between accessibility and pediatric oversight. Immunization authority includes vaccines recommended by the CDC or authorized by the Department of Public Health, as well as emergency use immunizations during outbreaks. Pharmacists and supervised student pharmacists or trained technicians must complete an accredited immunization training course. Maintain current basic life support certification. Follow proper vaccine storage and handling protocols. Document every administration and notify the patient's primary care provider when applicable. In practice, this means the pharmacist isn't just filling prescriptions, they're shaping public immunity, one patient at a time. Naloxone dispensing Illinois pharmacists have the authority to dispense naloxone, the opioid overdose reversal drug, without an individual prescription. Uh, this is done under a standing order or statewide protocol issued by the Department of Public Health. The pharmacist must provide counseling on recognition of overdose, proper administration of naloxone, and emergency follow-up. They must also maintain records of each dispensing, just as with any other prescription. This provision transforms pharmacies into access points for life-saving medication, a major public health achievement. Hormonal contraceptives and preventive therapies. Under current law, pharmacists may prescribe and dispense self-administered hormonal contraceptives after completing department-approved training and following established screening and counseling protocols. The pharmacist must document the encounter, provide a fact sheet on risks and benefits, and refer the patient to a physician for follow-up care as needed. This authority reflects a growing recognition of pharmacists as gatekeepers of preventive health, helping patients access essential care without unnecessary barriers. HIV prevention, PrEP and PP. Illinois has recently expanded pharmacists' authority to initiate or furnish pre-exposure prophylaxis, PrEP, and post-exposure prophylaxis, PEP, for HIV prevention. Pharmacists must complete specific training, conduct risk assessments, provide counseling, and ensure appropriate laboratory testing. They must also refer patients to primary care providers for ongoing management. For the MPJE, remember, this authority comes through statewide protocols, not individual collaborative agreements. Tobacco cessation programs. Pharmacists may initiate and manage tobacco cessation therapy using nicotine replacement products and behavioral counseling. This authority also stems from statewide protocols and supports Illinois' efforts to reduce chronic disease through accessible intervention. In all these cases, naloxone, contraceptives, PrEP, tobacco therapy, the law follows a simple pattern: protocol-based autonomy. You act within the law's boundaries, but with the flexibility to make immediate, meaningful public health interventions. Emergency dispensing authority. Illinois law allows pharmacists limited authority to dispense emergency refills when patient health would otherwise be endangered and the prescriber cannot be reached. In such cases, the pharmacist may dispense a reasonable quantity to maintain therapy until contact is made. Document the reason for dispensing. Notify the prescriber as soon as possible. Controlled substances, especially Schedule II drugs, are excluded unless permitted under federal emergency provisions. The goal is continuity of care, making sure patients don't suffer harm because of timing or logistics. Public health emergencies. During declared disasters or public health emergencies, the governor or the department may temporarily relax certain regulatory requirements to ensure patient access to medications. Pharmacists may be authorized to administer vaccines or medications beyond normal scope, dispense without prior prescriptions under standing orders, substitute therapeutically equivalent drugs during shortages, operate mobile or temporary pharmacy units. These emergency powers were heavily used during the COVID-19 pandemic, illustrating how pharmacists can adapt quickly when the system around them slows down. Mandatory reporting. Pharmacists are required to report certain information to maintain public safety, such as theft or loss of controlled substances, reported to DEA and IFPR immediately, suspected drug diversion or impairment among pharmacy personnel, changes in employment, name, or address to the department within a defined period. Failure to report these events isn't a minor oversight, it's a professional violation. Reporting keeps the system transparent and ensures issues are addressed before harm occurs. Prescription Drug Monitoring Program, PDMP, in public health. Beyond its role in controlled substances, the PDMP functions as a public health surveillance tool. Aggregated, de-identified data helps track opioid trends and guide state policy. For pharmacists, checking PDMP data before dispensing Schedule 2V medications helps identify potential abuse, but it also helps prevent accidental duplication and supports coordinated care. It's both a compliance step and a public health measure. Education and community engagement. The Act implicitly supports pharmacists' roles in public education, encouraging safe medication use, disposal, and adherence. Community presentations, drug take-back events, and health screenings all fall within the spirit of the law. The more pharmacists engage in education, the stronger the connection between community health and professional trust becomes. Ethical foundations of public service. At its core, public health responsibility in pharmacy is an ethical duty to see beyond the counter and recognize that every patient interaction, a vaccination, a refill, a question answered, shapes the health of the community. Illinois law doesn't spell out every possible act of service. Instead, it gives pharmacists the authority to act in good faith when the public's well-being depends on them. That's what separates professionals from providers of products. How this appears on the MPJE expect questions that blend clinical judgment and legal boundaries, such as, can a pharmacist furnish naloxone to a family member? Yes, under protocol. A 10-year-old requests a flu vaccine. Yes, pharmacist may vaccinate age 7 and older. During an emergency, the governor authorizes mobile pharmacy units. What must the pharmacist do before opening? Notify the department and comply with temporary rules. The key is to think like a clinician who knows the law, flexible but never reckless. The broader vision, Illinois sees pharmacists as an untapped public health force, accessible, trusted, and scientifically trained. The law reflects this confidence by granting new authorities each decade. Public health is where pharmacy's technical skill meets its human mission. When you vaccinate, educate, or respond in a crisis, you're practicing lawfully. But more importantly, you're fulfilling the profession's promise to safeguard life beyond the prescription pad. Part 9, the Illinois State Board of Pharmacy and Administrative Structure. Behind every rule, inspection, and disciplinary letter, there's a structure guiding how pharmacy is regulated. Most pharmacists think of the board as a distant authority, but understanding how it actually functions makes the law feel a lot less mysterious. The Board of Pharmacy isn't just an enforcer, it's the profession's bridge to the government. Its purpose is to ensure that the voice of pharmacists remains part of every decision about pharmacy practice in Illinois. The role and mission of the board. The Illinois State Board of Pharmacy exists to advise the Department on Financial and Professional Regulation, IDFPR, on all matters related to pharmacy. It's not a separate agency. It's a professional body that lends expertise, reviews cases, and helps the department interpret gray areas of the law. Think of the department as the executive branch and the board as its professional conscience. Together, they balance enforcement with fairness, making sure rules protect the public without stifling the profession. The board's mission can be summed up simply: protect the health, safety, and welfare of Illinois citizens, promote and maintain high professional standards, support the advancement of pharmacy practice. Composition of the board. The board is made up of 9 members, appointed by the governor and confirmed by the Senate. Of these 9, 7 must be licensed pharmacists actively engaged in practice, and 2 must be public members, individuals who are not pharmacists, not connected to the profession, and represent the perspective of patients and consumers. This mix ensures balance between professional knowledge and public accountability. Each pharmacist member must have at least 5 years of experience practicing in Illinois and be in good standing. Appointments typically last 5 years, and members may be reappointed for consecutive terms if the governor chooses. If a seat becomes vacant due to resignation, death, or removal, the governor appoints a replacement to serve the remainder of the term. Officers and organization. The board elects its own chairperson and vice chairperson, usually from among the pharmacist members. The department provides administrative support, staff, meeting space, and legal counsel, but the board sets its own meeting agendas and priorities. Meetings occur at least 4 times per year and are open to the public unless discussing confidential disciplinary or investigative matters. These sessions are where regulatory updates, rule proposals, and professional issues are debated. In essence, the board functions as a think tank, policy advisor, and judicial panel rolled into one. Powers and duties. Under the Pharmacy Practice Act, the board's powers include 1. Advising the department on rules, policies, and standards affecting pharmacy practice. 2. Reviewing license applications and recommending approval or denial in special cases. 3. Conducting disciplinary hearings and making recommendations on sanctions. 4. Reviewing continuing education standards and approving acceptable CE providers. 5. Promoting public education on safe and effective medication use. The board cannot directly issue, suspend, or revoke licenses. That authority rests with the department. However, the department rarely acts without the board's input, especially on technical or ethical matters. Disciplinary hearings and recommendations. When a pharmacist, technician, or pharmacy faces potential discipline, the case is often heard before the board. An administrative law judge, ALJ, oversees the proceeding, while board members review evidence, hear testimony, and ask questions. After the hearing, the board submits a recommendation to the department's director. The director may accept, reject, or modify the recommendation, but must explain any departure from it in writing. This ensures transparency and prevents arbitrary punishment. For the MPJE, remember, the department decides, but the board advises. Rulemaking authority. The department, with the board's advice, may adopt or amend rules and regulations to carry out the act. These rules are codified in the Illinois Administrative Code, specifically Title 68, Part 1330. While statutes establish the what, administrative rules define the how. For example, the statute says pharmacists must complete continuing education. The rules specify how many hours, what subjects count, and how records must be maintained. Understanding this distinction is crucial on the MPJE. It's often the difference between a right answer and a nearly right one. Communication and transparency. The board maintains open communication with the profession through newsletters, public postings, and department announcements. When new rules or interpretations are issued, they're typically published on the IDFPR website and sometimes in the Illinois Register. Pharmacists are expected to stay informed. Ignorance of new regulations is not a defense. The law assumes that licensees keep up with their own governing body. Public participation. Illinois law values transparency. Any citizen may attend public portions of board meetings, submit written comments, or petition for changes in rules. This openness serves two purposes. It keeps the board accountable, and it reminds pharmacists that their profession exists within a broader public trust. Many of the most meaningful reforms in Illinois pharmacy law, from technician training to expanded vaccine authority, began as board discussions shaped by public input. The board's relationship with other agencies. The board collaborates with several state and federal bodies, including the Illinois Department of Public Health, IDPH, on immunization and emergency response programs, the Drug Enforcement Administration, DEA, on controlled substance matters, the Illinois Department of Human Services, DHS, for the Prescription Drug Monitoring Program, the Food and Drug Administration, FDA, and other agencies for product recalls or safety alerts. This web of partnerships ensures that pharmacy regulation stays coordinated, consistent, and science-based. Removal and conduct of board members. Board members are expected to maintain professionalism and impartiality. They may be removed by the governor for misconduct, neglect of duty, or incapacity. They must also recuse themselves from any case in which they have a conflict of interest, for example, if the respondent is a coworker or competitor. Members receive modest compensation and reimbursement for travel, but most serve out of professional pride and commitment to the field. How this appears on the MPJE, questions about the board often test structure and roles rather than trivia. Examples: who appoints members of the Board of Pharmacy? The governor. How many public members must the board include? 2. Who issues final disciplinary orders? The department, after board recommendation. The takeaway: the board is the expert voice. The department is the legal authority. Why the board matters. To the average pharmacist, the board may seem like an administrative body in Springfield. In reality, it's the profession's shield and compass. When new technologies emerge, when federal guidance changes, or when public expectations shift, The board ensures that pharmacists, not just politicians, have a say in shaping the rules. The Illinois Pharmacy Practice Act isn't static because the board isn't static. It evolves through discussion, feedback, and advocacy. And understanding that process helps every pharmacist see themselves not just as licensees, but as stakeholders in the profession's future. Part 10: Ethics, Professional Conduct, and the Future of Illinois Pharmacy. Every law has a spirit behind it. For the Illinois Pharmacy Practice Act, that spirit is ethical responsibility. The idea that pharmacists are professionals first, merchants second. Ethics is the thread that ties every rule in the act together. It's what turns compliance into care. The meaning of professional conduct. Professional conduct is more than following regulations. It's living up to the trust society gives pharmacists. Illinois law expects pharmacists to demonstrate honesty, compassion, and fairness in every interaction with patients, prescribers, colleagues, and regulators alike. This means avoiding conflicts of interest, maintaining confidentiality, and ensuring that every decision serves the patient's best interest. The law cannot possibly list every situation you'll face in practice, so it relies on your ethical judgment to fill the gaps. When a pharmacist hesitates between what's legal and what's right, ethics is the compass that points toward both. Integrity in practice. Integrity means consistency, doing the right thing even when no one is watching. In Illinois, integrity shows up in how prescriptions are verified, how counseling is offered, how technicians are supervised, and how errors are handled. A pharmacist who admits a mistake, documents it properly, and takes steps to prevent recurrence shows integrity. One who hides or ignores an error violates not just the law, but the foundation of public trust. On the MPJE, ethics questions often disguise themselves as scenarios about record keeping, counseling, or refusal to dispense. The answer is usually found by asking, which action protects the patient and upholds professional honesty? Respect for patients and the public. Pharmacists serve diverse communities. Patients bring different languages, beliefs, and abilities to the counter, but each deserves equal respect and access to care. Illinois law views discrimination in healthcare as unprofessional conduct. Respect also includes protecting patient privacy. Conversations about medications should be held discreetly. Records must remain secure, whether paper or digital. Gossiping about a patient's therapy, even casually, can qualify as a breach of confidentiality. A respectful pharmacist sees every patient not as a transaction, but as a person navigating the complexities of health. Avoiding conflicts of interest. Pharmacists must avoid any situation where financial or personal interests could compromise professional judgment. This includes accepting incentives to promote certain products, filling prescriptions solely to meet quotas, or favoring one prescriber's business over another's. Corporate owners cannot pressure pharmacists to meet metrics that violate professional standards. When business goals collide with patient care, the law is clear. Professional judgment wins. Duty to report and protect ethical responsibility also means speaking up. Pharmacists must report suspected diversion, fraud, or impairment among coworkers. They must act when they believe a prescription poses serious harm. Reporting is not betrayal, it's protection. Illinois law provides mechanisms for confidential reporting through the department or recovery programs. A pharmacist who intervenes early can prevent harm and preserve another's career. Substance use and impairment. The law distinguishes between misconduct and illness. Pharmacists struggling with substance use or mental health issues are encouraged to seek help through the state's pharmacy recovery program before their condition endangers the public. The program emphasizes rehabilitation, confidentiality, and reintegration into practice. Ethically, acknowledging impairment is not weakness, it's courage aligned with the duty to protect patients. Ethical decision-making in daily practice. Pharmacists face ethical crossroads every day. A patient wants an early refill of a controlled substance, a doctor prescribes a dangerously high dose, a technician makes a labeling error. The law provides structure, but ethics provides direction. The correct decision usually protects safety, transparency, and honesty, even when it's inconvenient. Illinois expects pharmacists to document their reasoning, communicate openly, and act in good faith. When judgment calls are documented clearly, they become defensible both ethically and legally. Confidentiality and trust. The entire practice of pharmacy rests on confidentiality. Patients disclose private details they might not share with anyone else. That trust is sacred. Disclosing protected information without authorization, whether intentionally or by carelessness, is one of the fastest ways to lose that trust and your license. Electronic health records and automated systems don't change the rule. Only share what is necessary, only with those entitled to know. Trust is earned in whispers, not announcements. Professional relationships. Pharmacists work within teams. The law assumes cooperation between pharmacists, physicians, nurses, and other providers. Ethical relationships are built on mutual respect, communication, and accountability. Criticizing other professionals in front of patients, forging signatures, or altering prescriptions erodes confidence in the entire healthcare system. Collaboration, not competition, defines ethical practice. Continuing education as an ethical obligation. Continuing education isn't just a requirement, it's an ethical commitment to lifelong competence. Medicine changes daily. What was safe 5 years ago might not be today. Each renewal cycle is an opportunity to refresh skills, expand knowledge, and uphold the trust patients place in you. Ignorance is never a defense when harm occurs, and the law recognizes willful ignorance as negligence. A pharmacist who keeps learning protects more than their license. They protect their patients' lives. The future of Illinois pharmacy. Pharmacy is changing faster than any statute can keep up. Automation, artificial intelligence, telehealth, and new therapies are redefining what it means to be a pharmacist. The Illinois Pharmacy Practice Act adapts slowly, but its principles are timeless. Competence, accountability, and patient-centered care. The future belongs to pharmacists who can think critically, communicate clearly, and act ethically in new environments, whether that's a hospital ward, a clinic, a screen, or a small-town counter. Ethics will remain the anchor. No matter how much technology evolves, the pharmacist's role as the moral center of medication use will never fade. The legacy of the Act, the Illinois Pharmacy Practice Act, is more than a legal framework. It's a living document that tells the story of a profession rising to meet modern healthcare's challenges. Every amendment marks a step toward broader responsibility and deeper trust. To know this law is to know what it means to be a pharmacist in Illinois. Competent in science, grounded in ethics, devoted to the public good. That's the promise every license carries, and the standard every pharmacist must keep. Part 11. Inspections, investigations, and compliance. The Illinois Pharmacy Practice Act does more than define what pharmacists should do. It also explains how the state ensures they actually do it. Every licensed pharmacy in Illinois is subject to inspection and oversight by the Department of Financial and Professional Regulation. These inspections are not meant to intimidate. They exist to protect the public, identify problems early, and preserve the integrity of the profession. The purpose of inspection. An inspection is a professional audit, not a punishment. Inspectors visit pharmacies to verify that operations meet the standards set by law. They look for proper record keeping, adequate staffing, current licenses, appropriate storage conditions, and safe dispensing procedures. In Illinois, inspection authority comes directly from the department. Inspectors can enter a pharmacy during regular business hours without a warrant. They have the right to examine records, interview staff, and inspect equipment or drug stock. The intent is not to catch good pharmacists doing something wrong, but to ensure that every pharmacy, from big chains to rural independents, operates with the same baseline of safety and competence. Preparing for inspection. A compliant pharmacy never fears inspection. Preparation isn't about last-minute cleanup. It's about everyday discipline. A well-run pharmacy keeps current policies, organized records, clean work areas, and accessible documentation. The pharmacist in charge holds direct responsibility for inspection readiness. That means all licenses and certificates are displayed. Prescription and inventory records are complete and retrievable. Controlled substances are secured and reconciled. Refrigerators maintain proper temperatures and logs. Technicians and trainees are registered and trained. When inspectors walk in, everything they need should already be in place. During an inspection, inspectors may ask questions, review procedures, and request sample records. They may count inventory or verify that counseling and labeling standards are being met. Pharmacists and staff are required to cooperate. Refusing inspection, providing false information, or obstructing an investigator can result in immediate disciplinary action. If deficiencies are found, inspectors document them in a written report. The pharmacy may be given a period to correct issues before penalties are considered. Transparency, humility, and quick correction usually go further than excuses. Common deficiencies. Inspections often reveal patterns, not malicious misconduct, but simple oversights. Among the most common are failure to maintain 5-year prescription records, out-of-date reference materials, missing or expired technician registrations, incomplete perpetual inventories of Schedule II drugs, outdated or missing policies for counseling or error documentation. These are avoidable problems. A good pharmacist in charge reviews compliance checklists regularly, treating them as part of operations rather than interruptions. Investigations and complaints. An investigation is different from a routine inspection. It begins when the department receives a complaint from a patient, another professional, or law enforcement. Investigators gather information, interview witnesses, and review records. If the allegation involves controlled substances, the DEA may participate. The process is confidential until formal charges are filed. Pharmacists under investigation have rights to be notified, to present evidence, and to be heard before disciplinary action is taken. The Board of Pharmacy reviews the findings and advises the department on next steps. The key to surviving an investigation is honesty. Concealing facts or falsifying records always worsens the outcome. Corrective actions and follow-up. When violations are found, the department may issue a warning, require corrective training, or impose fines. For serious or repeated offenses, suspension or revocation may follow. Pharmacies must submit written plans describing how they will correct deficiencies. Inspectors may return to verify compliance. Restoration of good standing depends not just on fixing paperwork, but on demonstrating sustained improvement. Illinois prefers education over punishment. A pharmacist who learns from a mistake is an asset to the profession. One who repeats it is a liability. Self-audits and internal compliance. The best pharmacies don't wait for inspectors. They inspect themselves. Periodic self-audits help identify weaknesses before they become violations. Reviewing controlled substance counts, temperature logs, counseling documentation, and CE records keeps everyone ready for real scrutiny. Self-audits also strengthen a pharmacy's defense if questions arise later. Demonstrating an ongoing commitment to compliance shows regulators that lapses, if any, were unintentional and quickly corrected. Communication with inspectors, professionalism matters as much as paperwork. Inspectors are not adversaries. They are representatives of the same goal, patient safety. Treat them respectfully, answer questions directly, and provide requested materials promptly. If you disagree with a finding, note it in writing, but remain cooperative. Every interaction becomes part of the record, and courtesy often influences the tone of enforcement. Continuous compliance culture. The ultimate goal is a culture where compliance happens naturally. That means every technician knows their duties, every pharmacist understands their authority, and every process has a safeguard built in. A pharmacy that operates with transparency and consistency doesn't need to prepare for inspections. It's always ready. The same is true of the individual pharmacist. When your documentation, decision-making, and ethics align, the law becomes a framework for confidence rather than fear. How this connects to the MPJE exam questions about inspection and compliance often hide within scenarios. A pharmacist refuses to show records, violation. A technician helps inspectors access the PDMP without supervision, violation. A pharmacy corrects deficiencies within 30 days and documents changes, compliance. The MPJE wants you to think like the department, protect the public, act in good faith, and document everything. The bigger picture inspection and compliance aren't the enemies of independence. They're the proof of professionalism. When pharmacists welcome oversight, they demonstrate that the profession can police itself. In Illinois, that mutual trust between the department and the profession is the quiet engine that keeps pharmacy running safely for everyone. Part 12, Renewal, Continuing Education, and Maintenance of Licensure. Earning a pharmacy license is a milestone, but keeping it active is a lifelong responsibility. Illinois law treats renewal not as a formality, but as proof that a pharmacist remains competent, ethical, and engaged with the profession. Licensure is the state's ongoing conversation with the pharmacist. Are you still current? Are you still capable? Are you still committed to patient safety? Renewal cycles pharmacist licenses in Illinois must be renewed every 2 years on the even-numbered year cycle. Renewal notices are typically sent by the Department of Financial and Professional Regulation several weeks before expiration, but the ultimate responsibility rests with the pharmacist. Renewal requires three things. 1. A completed renewal application submitted online or by mail. 2. Payment of the renewal fee. 3. Proof of continuing education, CE. If the pharmacist fails to renew by the deadline, the license automatically expires, and the individual may not practice until reinstated. Practicing even 1 day with an expired license is a violation of the Act, one that can result in fines or discipline. Continuing education requirements. The cornerstone of renewal is continuing education. Every licensed pharmacist must complete 30 hours of CE during each 2-year renewal period. The hours must come from approved providers such as ACP-accredited programs or recognized state national pharmacy associations. Include at least 1 hour in pharmacy law and 1 hour in patient safety. Be completed before the license expiration date. CE may be completed online, in person, or through home study. Excess hours cannot be carried over to the next renewal cycle. Documentation must be retained for at least 5 years in case the department requests verification. Waivers and exemptions. Under limited circumstances, the department may grant a waiver or extension of CE requirements. Typically for serious illness, military service, or hardship, requests must be made in writing before the renewal deadline and supported by documentation. Waivers are exceptions, not conveniences. The department rarely excuses noncompliance based on oversight or lack of time. Technician renewal and CE pharmacy technicians in Illinois renew annually, not biennially. They must complete 10 hours of CE each year, at least 1 hour of which must cover pharmacy law or patient safety. Certified pharmacy technicians, CPHTs, must maintain their national certification in addition to the state CE requirement. Failure to complete CE or renew on time results in expiration of registration, making the technician ineligible to work until reinstated. Inactive and expired status. A pharmacist who temporarily leaves practice, for example during relocation, extended illness, or family leave, may choose to place their license on inactive status. Inactive status means the license remains valid but unusable for practice. To return to active status, the pharmacist must pay the current renewal fee and demonstrate completion of required CE for the inactive period, up to a maximum determined by the department. If a license remains expired for more than 5 years, reinstatement requires not just fees and CE, but proof of current competence. The department may require additional coursework, examination, or verification of practice from another state. Reinstatement. Reinstatement after disciplinary suspension or voluntary surrender follows a formal petition process. The pharmacist must demonstrate rehabilitation, updated knowledge, and readiness to resume professional duties. This may include completing CE beyond the normal requirement, undergoing evaluations, or appearing before the board. Reinstatement is not automatic. It's earned through accountability and transparency. Display and verification. Active pharmacists must display their current license conspicuously at the primary place of practice. Pharmacies also display the facility license and the name of the pharmacist in charge. Patients have the right to verify licensure through the department's public database, which lists active, inactive, suspended, and revoked statuses. Transparency keeps the profession credible. Name, address, and employment changes. Pharmacists must notify the department promptly of any changes in name, home address, or employment. Failure to update this information result in missed notices, expired licenses, and disciplinary action. Updating contact information is more than administrative. It's part of maintaining a valid, traceable professional identity. Continuing professional development. While CE satisfies legal requirements, the Act encourages broader professional development. This includes mentoring new pharmacists, participating in quality improvement projects, and contributing to research or education. In Illinois, continuing competence isn't just measured by hours completed. It's reflected in how pharmacists use what they learn to enhance patient care. The MPJE may not test this concept directly, but understanding it shapes how you interpret every rule. Education is both a privilege and a duty. Common renewal pitfalls: most renewal problems are preventable. The most frequent mistakes include waiting until the last week to complete CE, forgetting to retain CE certificates, assuming the department will send a reminder, practicing after expiration, even briefly, failing to update contact information after a move. A responsible pharmacist tracks CE progress throughout the cycle and confirms renewal well before the deadline. The philosophy of renewal. Renewal represents the profession's promise to the public. I am still learning. I am still competent. I am still worthy of your trust. It's not a bureaucratic ritual, it's a reaffirmation of professional identity. The Act treats continuing education as the heartbeat of pharmacy regulation. Each course completed, each new skill learned, keeps the profession alive and relevant in a healthcare landscape that changes every day. Part 13, Controlled Substances, Special Situations, and Professional Judgment. Pharmacists who handle controlled substances walk a narrow path. Every decision, to fill, to refuse, to verify, carries both legal and ethical weight. This section focuses on the situations that test professional judgment most: borderline prescriptions, questionable patients, and unclear authority. The pharmacist's corresponding responsibility. Every controlled substance prescription involves two parties, the prescriber and the pharmacist. Both share equal responsibility for ensuring the prescription is issued and dispensed for a legitimate medical purpose in the usual course of professional practice. If the prescriber writes an improper order and the pharmacist knowingly fills it, both have violated the law. The term corresponding responsibility means you cannot hide behind the prescriber's signature. Your judgment matters just as much. Illinois law expects pharmacists to recognize patterns of abuse or diversion. Early refills, doctor shopping, cash-only patients, or prescriptions far outside normal dosing. The pharmacist must act, verify, document, or refuse. Verifying questionable prescriptions. When a prescription raises red flags, the pharmacist should contact the prescriber for clarification. Documentation is essential. Record the date, time, and details of the conversation. If the prescriber cannot be reached and the pharmacist still doubts legitimacy, the safe choice is to refuse to dispense. A refusal made in good faith is fully supported by law. A dispensed, questionable prescription, however, becomes the pharmacist's liability. The MPJE frequently tests this principle. The correct answer is almost always the one that shows caution, documentation, and patient protection. Refusal to dispense. Illinois law grants pharmacists the professional authority to refuse to fill a prescription if doing so would violate law or professional judgment. Valid reasons include suspected forgery or alteration, dangerous drug interaction or overdose risk, lack of therapeutic need or evidence of misuse, legal restrictions such as quantity or time limits exceeded. The pharmacist must document the refusal, inform the prescriber if appropriate, and, when possible, refer the patient to another pharmacy or provider. Refusal based on personal or moral beliefs must follow department guidance to ensure patient access is not obstructed. Controlled substance limits. Illinois follows federal scheduling but adds some state-specific controls. Schedule II drugs require written or electronic prescriptions, no refills. Schedules 3-5 allow up to 5 refills within 6 months. Methadone for maintenance or detoxification may only be dispensed by certified opioid treatment programs, not retail pharmacies. Buprenorphine, Suboxone, and similar may be dispensed with a valid data waiver or corresponding federal credential, though prescribers no longer need the old XDEA number. Illinois also restricts Schedule 5 codeine cough syrups and similar products, eliminating the over-the-counter exempt narcotic sales that once existed. Emergency dispensing and verbal orders. For Schedule II drugs, verbal orders are allowed only in true emergencies when no alternative is available. The pharmacist may dispense the minimum quantity necessary and must receive a signed prescription within 7 days. For Schedules 3-VI, prescribers may transmit verbal or faxed prescriptions, provided the pharmacist promptly reduces the order to writing and signs it. Even during emergencies, professional documentation is mandatory. Verbal order never means no record. Controlled substance inventory and reconciliation. Every pharmacy must maintain an accurate and current inventory of all controlled substances. Illinois requires complete inventories at least every 2 years with perpetual records for Schedule II items. Best practice is to conduct internal reconciliations monthly, especially for drugs with high diversion risk. Missing tablets, unaccounted refills, or unexplained discrepancies should be reported immediately to the DEA and the department. A pharmacist who discovers theft and delays reporting may face the same penalties as one who caused it. Theft, loss, and diversion reporting. Any significant loss or theft of controlled substances must be reported to 1. The DEA using Form 106, 2. The Illinois Department of Financial and Professional Regulation, 3. Local law enforcement if applicable. Reports should be filed within 1 business day of discovery. Pharmacists should secure records, identify quantities lost, and document corrective actions taken. Even small discrepancies matter. The department interprets significant based on pattern and potential for abuse, not quantity alone. Record keeping and storage. Controlled substance prescriptions and inventories must be stored separately or readily retrievable from other records. Illinois requires retention for 5 years, and all records must be accessible within 48 hours upon request. Storage areas must be secure, access controlled, and designed to deter theft. Digital records must have backup and audit trail capability. Compliance isn't about memorizing forms, it's about traceability. Every tablet must be traceable from receipt to patient. Compounding with controlled substances, pharmacists may compound preparations containing controlled substances when supported by a valid prescription. The compounded product inherits the schedule of the active ingredient. Bulk compounding for office use is prohibited unless the pharmacy holds proper DEA registration for manufacturing or distribution. Each compounded record must include formula, source of ingredients, quantities used, beyond use date, and pharmacist signature. Disposal of controlled substances. Expired or unwanted controlled substances may not be destroyed casually or returned to stock. Pharmacies must transfer them to a registered reverse distributor or follow DEA-authorized destruction procedures. On-site destruction requires prior DEA approval and 2 witness signatures. All activity must be logged, dated, and verified. Patients may return medications through authorized take-back programs, but never directly to a retail pharmacy unless registered as a collection site. Methamphetamine precursor control. Illinois enforces strict limits on the sale of pseudoephedrine and related precursors. Sales are tracked through an electronic log, and buyers must present identification. Limits include no more than 3.6 grams per day, no more than 7.5 grams in 30 days per individual. Pharmacists and technicians must ensure compliance and deny sales that exceed limits or appear suspicious. These transactions are not prescriptions, but they are legally controlled. Failure to document is treated like a dispensing violation. Accountability and professional judgment. The theme behind all controlled substance regulation is responsibility. Illinois law does not expect pharmacists to catch every falsified prescription, but it expects them to try. It expects diligence, not perfection, skepticism, not cynicism. Every controlled substance decision should answer 2 questions. 1. Is this prescription legally valid? 2. Is it therapeutically appropriate for this patient? If either answer is uncertain, the pharmacist must pause, document, and investigate. The best protection a pharmacist has is good judgment backed by good records. Controlled substances and the MPJE. On the MPJE, questions about controlled substances often test professional reasoning rather than rote memorization. A typical question might describe an ambiguous situation: a questionable prescriber, an out-of-state patient, a refill request too soon. The correct choice is almost always the one that safeguards patient welfare, follows documentation protocol, and errs on the side of caution. Illinois law doesn't want pharmacists to be detectives. It wants them to be responsible professionals who recognize when something doesn't feel right and act accordingly. Part 14, Compounding, Manufacturing, and Product Integrity. The Illinois Pharmacy Practice Act draws a clear line between compounding, which is a professional act performed for an individual patient, and manufacturing, which is a commercial act performed for distribution. Pharmacists who understand that line protect both their patients and their licenses. The purpose of compounding exists to meet specific patient needs that cannot be met by commercially available products. This may include changing dosage forms, avoiding allergens, combining compatible ingredients, or preparing discontinued medications. Illinois recognizes compounding as part of the practice of pharmacy, not a separate specialty. It relies on professional judgment, scientific knowledge, and ethical standards. Compounding is a service, not a shortcut around manufacturing laws. Patient-specific requirement. Every compounded prescription in Illinois must be based on a valid patient-prescriber-pharmacist relationship. That means a legitimate prescription order is required. The medication must be intended for a specific identified patient. The pharmacist must keep detailed formulation and dispensing records. Bulk compounding for office use, resale, or general stock is not permitted unless the pharmacy holds appropriate federal registration as an outsourcing facility or manufacturer. This principle shows up frequently on the MPJE. Always assume that compounding without a prescription for an individual patient violates the Act. Documentation and formulation records. Each compounded product must have two sets of documentation. One master formulation record, the formula, ingredients, procedures, and quality control steps. Two, compounding record specific to the batch or prescription showing ingredients, lot numbers, quantities, preparer, verifier, and beyond use date. Both records must be retained for at least 5 years and must be available for inspection. The Act treats incomplete documentation as a serious violation, even when the product itself is correct. The law's logic is simple. If it isn't written down, it didn't happen. Quality and safety standards. Illinois requires adherence to the standards of the United States Pharmacopoeia, USP, USP 795 for non-sterile compounding, USP 797 for sterile compounding, and USP 800 for hazardous drug handling. These standards govern everything from air quality to cleaning frequency to staff training. Pharmacies must maintain policies that describe environmental monitoring, equipment calibration, and product testing when applicable. Even small-scale compounding must meet cleanliness and documentation requirements. Professional skill does not replace procedural rigor. Labeling requirements. Labels for compounded products must include patient's name, prescriber's name, date of preparation, name and strength of ingredients, beyond use date, storage conditions, and cautionary statements. The phrase, "This is a compounded preparation." Beyond use dates are based on stability data or default USP limits, not manufacturer expiration dates. For the MPJE, remember that these shorter dating rules are part of protecting patient safety. Sterile compounding. Sterile compounding carries the highest risk and is one of the most closely regulated aspects of practice. Facilities must maintain certified clean rooms or isolators, meet air quality standards, and ensure personnel undergo ongoing training and gloved fingertip testing. Any contamination, breach of a septic technique, or expired certification can trigger immediate inspection or license action. Illinois expects sterile compounding pharmacies to meet hospital-grade safety standards, even if they operate in community settings. Hazardous drugs. Drugs classified as hazardous under USP 800 require additional precautions: separate storage, negative pressure rooms, protective equipment, and spill procedures. Pharmacists must ensure that both staff and environment are protected. Patients deserve safe, uncontaminated medication. Workers deserve protection from exposure. Noncompliance here isn't just regulatory, it's a matter of occupational safety law. Outsourcing facilities. Some pharmacies register as outsourcing facilities under federal law to compound large batches for institutional or physician office use. These entities fall under the oversight of the FDA as well as the state. An outsourcing facility must comply with current good manufacturing practices, CGMP, maintain product testing programs, and report adverse events. Illinois requires dual registration, federal outsourcing certification, and state pharmacy licensure. For the MPJE, this distinction is key. A regular retail pharmacy cannot legally supply compounded drugs for resale. Prohibited acts. Illinois prohibits compounding commercially available products unless they are unavailable, discontinued, or require modification for a specific patient need. Advertising compounded drugs as safer or better than manufactured equivalents. Using non-FDA approved bulk ingredients. Distributing compounded products to other pharmacies without proper authorization. Violations can result in discipline, fines, or referral to the FDA for enforcement under federal law. Inspections and testing. The department may inspect compounding areas at any time. Inspectors review logs, equipment maintenance records, and personnel testing data. They may collect samples for analysis. Pharmacies should be prepared to show that every batch is traceable, every employee is trained, and every procedure is documented. When deficiencies are found, prompt correction and cooperation are expected. Beyond use dates and stability. The concept of beyond use dating is central to compounding safety. It ensures that each preparation maintains potency and purity for the time it remains in a patient's possession. Default USP dating rules include non-aqueous formulations, 6 months or earliest expiring ingredient, aqueous oral formulations, 14 days refrigerated, topicals, creams, or other aqueous preparations, 30 days. Sterile compounding follows far stricter dating based on risk levels and storage conditions. Compounding and the MPJE compounding questions on the MPJE often test the boundaries between compounding and manufacturing. For example, a pharmacy prepares 100 vials of a cream in advance for physician offices. That's manufacturing. A patient needs a gluten-free version of a commercial suspension. That's legitimate compounding. The test rewards those who understand intent. If the activity serves a patient-specific therapeutic need, it's compounding. If it serves a market, it's manufacturing. Professional judgment and integrity compounding is one of the purest expressions of pharmacy's science. It turns knowledge into individualized care, but it also carries the weight of absolute trust. Patients and prescribers rely on the pharmacist's skill and honesty because there is no manufacturer to guarantee safety. Every compounded product carries your name, your judgment, and your accountability. That's what makes compounding both an art and a legal responsibility. Part 15. Across state lines, mail order, non-resident, and telepharmacy, practice pharmacy no longer ends at the state border. A patient in Illinois may receive medication from a facility in Texas. A pharmacist in Chicago may verify prescriptions for a store in another region. The Illinois Pharmacy Practice Act recognizes this new reality, but insists that any pharmacy serving Illinois patients must uphold Illinois standards. The meaning of non-resident pharmacy. A non-resident pharmacy is any pharmacy located outside Illinois that ships, mails, or delivers prescription drugs to Illinois patients. Before doing so, it must obtain an Illinois non-resident pharmacy license from the Department of Financial and Professional Regulation. This requirement applies equally to mail order facilities, internet pharmacies, and out-of-state compounding operations. The goal is uniform accountability. If an Illinois patient receives a medication, that pharmacy falls under Illinois jurisdiction. Requirements for non-resident pharmacies. To receive a license, the out-of-state pharmacy must hold a valid license in its home state, submit an application to the Illinois Department with ownership, personnel, and location details, designate a pharmacist in charge who is licensed in the home state and accessible to the department, comply with all Illinois laws governing labeling, counseling, and record retention, provide a toll-free telephone number available during normal business hours for Illinois patients. The license must be renewed every 2 years, and any disciplinary action in the home state must be reported to Illinois immediately. Failure to meet these requirements can result in suspension or revocation of the Illinois non-resident license, even if the home state license remains active. Mail order and central fill pharmacies. Mail order pharmacies operate under the same laws as community pharmacies, with additional expectations for accuracy and communication. Each prescription must be verified by a pharmacist before shipping, packaged securely, and labeled clearly with instructions and contact information for counseling. Pharmacists must offer patient counseling via telephone or telehealth platform, just as they would in person. Documentation of the offer and completion of counseling is required. Central fill arrangements, where one pharmacy fills prescriptions for another, are permitted if both locations are licensed, share common ownership or contracts, and maintain proper record linkage. Every step must be traceable to a responsible pharmacist, telepharmacy. Telepharmacy bridges distance with technology. It allows a pharmacist at one site to supervise technicians or student pharmacists at another through secure, real-time audio-visual communication. Telepharmacy is designed to expand access to care in rural or underserved areas, but it operates under strict conditions. Both the home and remote sites must be licensed by the department. The supervising pharmacist must be able to view all prescription and patient data electronically. Counseling must occur live via video or telephone before the drug is released. All dispensing records must identify both the verifying pharmacist and the remote site. The law treats telepharmacy actions as if they occurred under the pharmacist's direct supervision. Distance does not dilute accountability. Internet pharmacies. Pharmacies that receive prescriptions electronically or advertise online must ensure compliance with both state and federal law. The mere presence of a website offering to ship medications into Illinois triggers the requirement for a non-resident pharmacy license. The department and federal authorities take special interest in rogue internet pharmacies that operate without prescriptions or outside U.S. jurisdiction. Illinois law aligns with the federal Ryan-Haight Online Pharmacy Consumer Protection Act, which prohibits dispensing controlled substances based solely on online questionnaires. Legitimate online pharmacies must verify prescriber-patient relationships and provide live pharmacist access for questions. Out-of-state compounding. If a non-resident pharmacy compounds medications for Illinois patients, it must follow Illinois compounding standards, even if its home state's laws are less stringent. This includes adherence to USP standards, patient-specific prescriptions, and appropriate labeling. Illinois inspectors may coordinate with other states to review facilities or records. Refusal to cooperate can lead to immediate suspension of the non-resident license. Prescription transfers between states. Illinois allows prescription transfers between in-state and out-of-state pharmacies, provided both are licensed and the transfer complies with federal law. The transferring pharmacist must record the name, address, and DEA number, if controlled, the date, and the pharmacist receiving the transfer. Controlled substances in Schedules 3 fee may be transferred only once unless both pharmacies share a real-time electronic database. Schedule 2 drugs may never be transferred once filled. Accuracy in documentation and patient communication remains the pharmacist's obligation, regardless of state boundaries. Disciplinary authority. The department may discipline non-resident pharmacies for acts that would violate Illinois law if committed within the state. This includes improper counseling, record-keeping failures, dispensing without valid prescriptions, or violations of controlled substance rules. The department can coordinate with the home state's Board of Pharmacy, but it retains independent authority to act in the interest of Illinois patients. Emergency and temporary operations. In declared disasters or emergencies, the department may permit out-of-state or temporary pharmacies to provide essential medication services in Illinois. These pharmacies must still register, even if expedited, and comply with safety and record-keeping requirements. This flexibility ensures that care continues when local infrastructure is disrupted without compromising oversight. The pharmacist's continuing responsibility. A pharmacist practicing across state lines, whether through mail-order verification, telepharmacy, or consulting, remains bound by the same ethical and professional standards. Patient safety, privacy, counseling, and documentation apply equally everywhere. Technology changes how prescriptions travel, but it doesn't change accountability. Each electronic verification, each label generated, carries the same legal weight as if handed directly to a patient across the counter. MPJE perspective across state line questions test comprehension of jurisdiction and professional duty. Does an out-of-state pharmacy need an Illinois license to ship into Illinois? Always yes. Can an Illinois pharmacist counsel remotely? Yes, if licensed and supervising through an approved telepharmacy system. Who enforces violations by non-resident pharmacies? The Illinois Department in cooperation with other state and federal agencies. The safe answer is always the one that protects Illinois patients first. The future of borderless pharmacy. The modern pharmacist works in a world where geography matters less than connectivity. Illinois law embraces this change, cautiously but confidently, ensuring that innovation never outruns responsibility. The message is simple. Wherever the prescription originates, wherever the patient resides, the standard of care remains the same. That is the promise of Pharmacy Without Borders, accountability that travels. Part 16. enforcement, penalties, and legal proceedings. Behind every professional privilege stands a mechanism for accountability. The Illinois Pharmacy Practice Act doesn't just grant authority, it enforces responsibility. Enforcement ensures that every pharmacist, technician, and pharmacy operates within the same ethical and legal framework, protecting patients from negligence, fraud, and abuse. The foundation of enforcement. The power to enforce the Act lies with the Illinois Department of Financial and Professional Regulation, IDFPR. Within the department, the Division of Professional Regulation oversees investigations, disciplinary actions, and compliance monitoring for all health professions, pharmacy included. Enforcement doesn't begin with punishment. It begins with observation, investigation, and due process. The department acts only after evidence shows that a violation of law or professional duty has occurred. How cases begin. Enforcement cases typically start with a complaint. Complaints can come from patients, prescribers, coworkers, employers, law enforcement, or even anonymous tips. Once received, the department reviews the complaint to decide if it falls within its jurisdiction and if the allegations, if true, would violate the Pharmacy Practice Act. If so, an investigation begins. Investigators may interview witnesses, review records, inspect pharmacies, or request written statements from the licensee. If evidence suggests wrongdoing, the department may file a formal complaint and set the matter for hearing. This process is administrative, not criminal, but its consequences can still end a career. Administrative hearings. An administrative hearing functions much like a court proceeding. The pharmacist or pharmacy receives formal notice of the charges and the opportunity to respond. The hearing is conducted by an administrative law judge, ALJ, who presides over testimony and evidence. The Board of Pharmacy may attend or participate, offering professional perspective. Both sides, the department and the licensee, may present witnesses, documents, and arguments. The ALJ compiles the record and submits findings and recommendations to the department's director, who issues the final decision. This system balances fairness with efficiency, allowing professionals to defend themselves while ensuring public protection. Types of violations. Violations range from clerical errors to gross misconduct. Common categories include fraud or misrepresentation on applications or renewals, dispensing errors or negligence resulting in patient harm, failure to maintain records or secure controlled substances, unlicensed practice or supervision failures, violations of confidentiality or ethical standards, criminal convictions related to drugs, theft, or moral turpitude. Each case is evaluated individually, considering intent, harm, and history. A single error rarely leads to severe punishment. A pattern of disregard usually does. Penalties and sanctions. The department can impose a wide range of penalties depending on the severity of the violation. Reprimand, a formal warning that remains part of the public record. Probation, continued practice under conditions such as supervision, counseling, or audits. Suspension, temporary loss of license until specified terms are met. Revocation, termination of the license with potential for future reinstatement. Fines and civil penalties, monetary sanctions for lesser or administrative violations. Cease and desist orders, immediate stop orders for unlicensed or unsafe practice. In cases involving patient harm, fraud, or diversion, the department may refer matters for criminal prosecution in addition to administrative discipline. Summary suspension. In emergencies, when the department determines that continued practice poses an immediate danger to the public, it may issue a summary suspension before a hearing. This suspension takes effect immediately, halting all practice privileges. The licensee is entitled to an expedited hearing soon after to determine whether the suspension should continue. Summary suspension is reserved for serious threats, diversion, impairment on duty, falsified records, or repeated gross negligence. It is the department's most powerful tool to protect the public quickly. Consent orders and settlements. Not all cases go to full hearing. Many are resolved through consent orders, where the pharmacist agrees to stipulated facts and accepts specified discipline. Consent orders save time and resources while allowing the pharmacist to avoid the uncertainty of litigation. However, they carry the same weight as a formal order and remain on the public record. Before signing a consent order, pharmacists are encouraged to seek legal counsel. Once accepted, it cannot be easily modified. Appeals and judicial review. If the department's final decision is disputed, the licensee may seek judicial review in the circuit court. The court examines whether the department acted within its authority and followed proper procedure. Courts rarely overturn factual findings, but they can reverse decisions made without evidence or in violation of due process. This appellate safeguard ensures fairness and prevents arbitrary or political decisions. Reinstatement after discipline. A pharmacist whose license has been suspended or revoked may petition for reinstatement after the required waiting period, typically 1 year for suspension, 3 years for revocation. The petition must show evidence of rehabilitation, completion of required CE or treatment programs, absence of new violations, letters of recommendation, or proof of good character. The board reviews the petition and makes a recommendation to the department, which then decides whether to restore the license, deny reinstatement, or impose conditions such as probation. Illinois favors redemption when genuine improvement is shown. Criminal penalties. Certain acts under the Pharmacy Practice Act constitute criminal offenses, such as practicing pharmacy without a license, counterfeiting prescriptions, knowingly dispensing controlled substances without valid prescriptions. These offenses may be prosecuted as misdemeanors or felonies, depending on severity, and conviction can result in imprisonment, fines, and automatic license revocation. Administrative and criminal proceedings can run in parallel. One handles professional status, the other personal liability. Public records and transparency. Disciplinary actions are public information. The department maintains an online database listing the status of every licensee, active, suspended, revoked, or on probation. This transparency reassures patients that the state actively monitors the profession. For pharmacists, it's a reminder that integrity and documentation protect not only patients, but reputations. Cooperation and mitigation. Pharmacists under investigation can often reduce penalties through cooperation, prompt correction, and candor. Hiding mistakes or obstructing investigators compounds the violation. Demonstrating awareness, remorse, and a plan for improvement shows the department that the pharmacist values compliance. In most cases, regulators seek rehabilitation, not destruction. The purpose of discipline is deterrence and education, not vengeance. MPJE implications. On the MPJE, enforcement questions often test whether you know who acts and how the process unfolds. The department enforces, the board advises. Hearings are administrative, not criminal. Final decisions rest with the director of the department. Summary suspension equals immediate stop, hearing later. Reinstatement equals petition and proof of rehabilitation. The right answer usually prioritizes due process, patient safety, and professional accountability in that order. The spirit of enforcement. Discipline and enforcement might sound harsh, but they exist to preserve the profession's integrity. Each pharmacist represents a promise to the public to act safely, honestly, and skillfully. Enforcement ensures that promise remains meaningful. When pharmacists uphold the law, they don't merely avoid punishment. They strengthen the collective reputation of everyone who wears the white coat. Part 17, The Future of Illinois Pharmacy Law and Professional Evolution. Every era of pharmacy redefines what it means to serve the public. The Illinois Pharmacy Practice Act began as a framework to ensure safe drug distribution. 4 decades later, it has evolved into a living document that tracks the transformation of pharmacists from dispensers to clinicians, educators, and public health advocates. This final section looks forward at the direction the law is heading, the pressures shaping it, and the mindset every modern pharmacist must carry to stay ahead. The expanding definition of practice of pharmacy. The Act's language has grown deliberately broad. What was once limited to compounding, dispensing, and labeling now includes clinical decision-making, collaborative therapy management, and patient education. Future updates are expected to continue this trend, expanding authority for chronic disease management, vaccination, point-of-care testing, and prescribing under statewide protocols. Illinois is part of a national movement recognizing pharmacists as accessible healthcare providers. With each legislative session, that recognition deepens. Technology and telehealth. Technology continues to reshape how pharmacists deliver care. Telepharmacy, electronic prescribing, and digital health records have already changed workflow. Artificial intelligence is beginning to assist with verification, interaction checks, and adherence monitoring. The law's challenge is to balance innovation with accountability, ensuring automation never replaces human judgment. Expect future regulations to address remote verification, AI-driven counseling tools, and interstate collaboration more explicitly. The pharmacist of tomorrow must be both clinician and technologist. Public health and preventive care. The next decade will likely expand pharmacy's preventive care role. Legislative attention is already shifting toward pharmacist-led testing for strep, flu, and COVID, chronic disease monitoring, and direct prescribing for contraception, smoking cessation, and PrEP. Illinois is also poised to integrate pharmacists more deeply into mental health and addiction recovery networks. Pharmacists, accessibility makes them key players in early intervention. Each new public health initiative will likely come with education, documentation, and CE updates, emphasizing that competence evolves with authority. Equity and access pharmacy law is also adapting to a broader social mission, healthcare equity. From language access requirements to telehealth outreach, regulators are recognizing that legal compliance includes removing barriers to care. Future versions of the Act may strengthen expectations for cultural competence, fair pricing transparency, and equitable access to pharmacy services in rural or low-income areas. The ethical pharmacist of tomorrow will see law not just as regulation, but as a tool for justice. Interprofessional collaboration medicine is no longer a solo act. Pharmacists now function within integrated teams that include physicians, nurses, social workers, and data analysts. Collaborative practice agreements, CPCAs, and statewide protocols are only the beginning. Expect broader use of shared care platforms where pharmacists adjust therapy in real time and document directly into the patient's record alongside prescribers. The law will evolve to clarify liability, communication standards, and data sharing requirements. But the spirit will remain the same: collaboration in the service of better outcomes. Regulatory modernization. Regulatory agencies are modernizing alongside practice. IDFPR is digitizing licensing, audits, and inspection systems. CE verification and PDMP use are increasingly automated. With modernization comes stricter traceability. Everything a pharmacist does leaves an electronic footprint. Transparency will grow, but so will efficiency. Renewals, compliance reporting, and patient protection will become faster and more data-driven. The successful pharmacist will embrace this visibility as proof of professionalism, not as surveillance. Ethical leadership. As laws expand, the ethical core must stay steady. Every new power, prescribing, testing, telehealth, demands renewed humility and honesty. When the law gives more authority, it silently asks for more wisdom. Ethical leadership will mean mentoring younger professionals, advocating for patient-centered policies, and resisting shortcuts that trade safety for convenience. The Pharmacy Practice Act can set boundaries, but only individual pharmacists can uphold the integrity that gives those boundaries meaning. Continuous education and lifelong adaptation. Continuing education will shift from passive hour counting to active professional development. Expect future requirements to include simulation-based training, competency assessments, and certification in emerging clinical areas. The pharmacist who thrives will be the one who sees education as growth, not obligation. Law and science will continue to evolve together, and pharmacists must evolve with them. The profession's public identity. Pharmacy's future in Illinois depends on visibility. The public trusts pharmacists deeply, but often misunderstands their full capability. Each new authority, immunizations, contraceptives, naloxone, is both a service and a statement. We are part of your healthcare team. As more pharmacists practice at the top of their license, the Act will follow, codifying what the profession proves it can do safely. The law changes because the profession earns it. The cycle of revision. The Illinois General Assembly revisits the Pharmacy Practice Act regularly, refining its language to keep pace with science and society. Every amendment begins with observation, a problem noticed in practice, a gap in access, a safety concern. Then come advocacy, research, and collaboration. Pharmacists who understand the law are best positioned to influence it. Participation in professional organizations, legislative outreach, and public testimony turn daily practice into progress. The next major changes to Illinois pharmacy law will almost certainly come from pharmacists who know this act inside out and care enough to improve it. The legacy of the Illinois Pharmacy Practice Act. From its origins in 1983 to its latest revisions, the act has evolved from a regulatory checklist into a professional charter. It captures the ongoing dialogue between law, science, and service, and it trusts pharmacists to interpret its spirit wisely. Every section, from controlled substances to telepharmacy, reflects the same underlying truth. Society depends on pharmacists not just to follow the law, but to embody it. The Illinois Pharmacy Practice Act is not merely a rule book, it's a mirror reflecting who pharmacists are and who they're becoming. The closing thought. The future of Illinois pharmacy law belongs to those who read it not as limitation, but as invitation to practice more broadly, think more deeply, and serve more fully. Every page of this act is ultimately about one thing: trust. Trust between the pharmacist and the patient, trust between the profession and the public, trust between the law and those who live by it. That trust is earned daily through skill, ethics, and compassion. And as long as pharmacists continue to honor that trust, the law will continue to evolve in their image.